Hello and welcome. I'm so glad to see so many of you join us today. I want to start with a simple question. How many of you have ever clicked the I agree button on a set of terms and conditions or signed a contract without actually reading the fine print? Come on. If you own an Apple device, you know you didn't read that entire thing. I know I didn't. Maybe it was a phone plan, a streaming service, or even a gym membership. At the time, it seemed harmless enough. Then, oops, you end up with a surprise charge, missing features, or are locked into a long term contract. It's then that you wish you'd paid more attention. Now, imagine the same situation, but this time it's not your phone or gym membership, it's your employee benefits plan. As a fiduciary, you're responsible for protecting your organization and employees. Paying attention to the details is crucial. Today, we're going to share some best practices for contracting with service providers to meet your fiduciary responsibility. Hi, I'm Jennifer Austin, Senior Director of Strategic Marketing and Employer Engagement here at the Alliance, where we help you self-fund smart. In today's session, we'll learn what encompasses your fiduciary duties, we'll identify key provisions in service provider contracts, and we'll learn effective contract strategies to ensure compliance and minimize risk. Before we get started, I wanted to remind you to use the chat box to ask your questions. We'll answer as many as we can at the end of today's program, and use your emoji buttons to let us know what's resonating with you. A copy of today's presentation slides is available to download from the resources box on your screen to help you follow along and take notes during the presentation. And the recorded video of this event will be available on our events page and YouTube channel. We will email a link to all attendees next week when it's available. Finally, I want to take a moment to thank Delta Dental, National Cooperative RX, and MH Imaging for their ongoing support. To learn more about how these partners can help your self-funded plan, click on the links in the resources box on your screen. We truly appreciate all our sponsor support. It allows us to continue bringing these valuable programs to you, our employers and partners. Today, I'm excited to welcome back John Barlament, a trusted friend of the Alliance. We've had the pleasure of hearing from John several times in the last few months, and he consistently delivers important, valuable content. If you missed the presentation he did in January, we put a link to it in the resources box on your screen, as well as a link to our YouTube channel, where you can check out all of John's previous presentations and other great content from the Alliance. If you haven't heard from John before, he's an employee benefits attorney who works with employers and health plan vendors on various legal issues with a focus on health and welfare plans. He is widely recognized as a national expert in these ever-evolving areas of law and has been featured in leading publications like the Wall Street Journal. Hi, John. Thanks for joining us today.
Thanks, Jennifer, and thanks everyone for being here today. Very excited to be here today. This is the third session, as Jennifer noted, that I've done for the Alliance over the past couple months, and so kind of the trilogy, the final one. So sort of excited about it. Obviously, there will be future ones too, but sort of excited to talk about ERISA and the CAA and best practices for contracting with your service providers to meet your fiduciary responsibilities. And this one's a little bit different than, I would say, some of the previous ones. For example, we talked before about mental health parity and all the kind of step-by-step things which you have to do with regard to some of those new MAPIA non-quantitative treatment limitation rules. This is a little bit different because when you start getting into contracts, you're really dealing more with best practices, I guess I'd say. There's sort of an infinite number of issues that could theoretically arise in a contract. So we have to be a little bit higher level in this session here. So, but we do think it'll be valuable to you all, and we hope that you will sort of understand how we got here, what laws should we be complying with, the needs for the written contracts, typical vendor contracts, and typical terms in those contracts, and things to look out for, strategies to minimize your risk. For example, one of the ones that we'll talk about later is try to be proactive. When you are thinking about changing vendors, what I encourage clients to do is to list in the RFP, even before they get the chance to respond, list off the key things that you think should be in that contract, whether it's limitations of liability, indemnification, access to data, whatever it is. That's a really helpful strategy because you sort of, in the contracting process, have the most leverage up front before you sign your name to the contract. Once you've kind of committed, it becomes a little bit harder. So again, we'll kind of talk about some of those sort of helpful tips and tricks here. How did we get here? So I wanted to give a little bit of a historical lesson, just so that people can kind of put it into context. Basically, from an ERISA perspective, ERISA was enacted in 1974, so about 50 years old, a little more than 50 years old now. But how did ERISA come into being? Well, what happened was there were a lot of different defined benefit retirement plans in the 1950s and 60s. If you back all the way up to World War II, there were wage controls which were implemented. So the federal government said you can't increase people's wages. So what happened? Companies said, well, let's increase their benefits. Let's start offering benefits. And so they started offering these benefits, including defined benefit plans. But the rules were very unclear. There just weren't a lot of rules. And so companies would use the assets for things other than retirement benefits. A good example of some concerns occurred in 1963. Studebaker, the big car manufacturer, had a very severely underfunded pension plan, and they went bankrupt. And a lot of people were left with basically nothing or very little in terms of their retirement benefits. Congress said, we can't have this. We've got to have some rules here. And so again, misuse of plan assets or making promises, but then not being able to deliver on those promises is a very fundamental thing that ERISA was trying to implement. And so ERISA kind of started it all. And then we've got a whole bunch of other regulations, of course, out there. COBRA, HIPAA, different things like that, Michelle's Law, CAA, ACA. So they all kind of build off of the ERISA step stool, if you will. And in addition to that, of course, if you have new laws, you need regulators to enforce those laws. And a lot of these are going to be familiar to you all if you've listened to previous sessions. The Department of Labor, DOL, IRS, Center for Medicare and Medicaid Services, CMS, Equal Employment Opportunity Commission, EEOC, state regulators, usually for non-ERISA plans. So again, if you have a plan that's not subject to ERISA, more of a CMS or state regulator issue. Participant lawsuits also are codified as part of ERISA. And so in some senses, plan participants are regulators also of these plans. And when you are sitting back and trying to think of, okay, which contracts do I need to worry about here? Look to the ERISA definition. And ERISA definition of a plan is really broad. So in the health plan context, we have the definition of an employee welfare benefit plan. Any plan, fund, or program established or maintained by an employer, an employee organization like a union, or both, to the extent that it provides medical, surgical, hospital, sickness, accident, disability, death, unemployment, vacation, apprenticeship, daycare, scholarship, or prepaid legal services to participants and beneficiaries. So really, really broad in terms of what is a employee benefit plan that's covered by these rules. There's also a whole different definition for retirement plans. There's also different rules for executive compensation plans. Executive compensation plans are ones that are typically offered to a select group of management within a company. A lot of times those plans will avoid some ERISA rules, but are often subject to other ERISA rules. So for example, they may avoid the summary plan description requirements, but they are subject to the ERISA claims procedure rules. So it does get to be kind of complicated because, again, there's a lot of sort of overlapping rules which are out there. Other plans in terms of exclusions here, church plans generally are excluded, but churches can make an election on the health plan side to become subject to ERISA. So church plans get a little bit confusing too. Plans maintained by certain governmental entities. So if you have a city, a county, a state, the state of Wisconsin has retirement plans, state of Wisconsin has a health plan, those are going to be exempt from ERISA. So that's usually perhaps a good thing. However, just because they're exempt from ERISA doesn't mean that there's no laws that they follow. There are state laws that they have to follow. For example, there have been situations where plans at the state level or at the county level, city level have been mismanaged. And then there have been breach of fiduciary duty claims, misappropriation of governmental asset type claims. So in some senses, non-ERISA governmental entities are actually subject to a whole bunch more rules because they have to follow a lot of the federal laws, even if they don't follow ERISA in its entirety. And then they're subject to state laws too. And those state laws are a little less well-defined. So they're not the easiest plans out there. They're subject to a lot of regulations. Top hat plans, again, those are for kind of that select group of management. Again, claims procedure rules apply. A lot of the disclosure rules, which are in Part 1 of ERISA, generally don't apply. Excess benefit plans, again, kind of those excess, sort of summary plans. What else is out there? So if you are subject to ERISA, I wanted to emphasize kind of the different aspects which you should be thinking through. Why? Because one strategy here is to kind of go through the ERISA requirements and try and figure out, okay, who's doing what? So for example, there are going to be reports which have to go to the Department of Labor, the Form 5500. Many of you are familiar with that, is one example of a report that has to go to the federal government. If you are kind of looking at your plans with a fresh perspective, with fresh eyes, you would say, okay, who's going to handle this piece? Who's going to do the 5500? Who's going to prepare it? What if there are errors associated with it? Who's going to fix it? Who's going to monitor it? That's the kind of step-by-step analytical approach you should take with regard to your plans. Now, for most of you, you probably have some kind of process in place, right? You probably have a 5500 process in place. You have a vendor who puts them together, maybe you do it yourself. You know who files it. Maybe it's you, maybe it's a vendor. So again, if you were kind of putting together a little to-do list, you could check that one off as saying, okay, here is our process that we follow right now. Other disclosures to plan participants, some relate to investments, again, more on the retirement plan side. Others a little bit more general. Summary plan descriptions, SPDs, are basically a summary of your plan document. It can also basically be the plan document too, generally speaking. And so SPDs are extremely common for all these different benefit plans which are out there. And when we go through the list of different benefit plans, think through the implications of that. For example, one of the ones that we'll mention in a couple of slides is on-site clinics. Those are pretty, small benefits usually, but if they're subject to ERISA, and they oftentimes are subject to ERISA, then somebody within your organization or a third-party vendor should be creating an SPD. Same thing with the summary annual report. Same thing with the summary material modifications and SMM. So again, there's a whole bunch of different, obligations which are out there, and you should think through, who is going to create these, who's going to update them, who's going to kind of work through these processes and legal requirements. Other things you should think through from a fiduciary perspective. Again, we wanted to kind of tie this back together. So from a fiduciary perspective, ERISA Title I Part 4 says that all ERISA covered plans, except for top hat plans, those kind of executive compensation plans, have to follow very stringent ERISA fiduciary duty rules. These ERISA fiduciary duty rules, some courts have said that they're the highest rules, highest obligations under applicable law. Where did they come from? When Congress was drafting ERISA in the early 1970s, it basically looked backwards in time to common law trust principles. What are common law trust principles? Those go back to even English times, so predate the United States, and where courts would say, if you are acting on behalf of somebody else in their best interest, then you really need to consider everything from their perspective. So you need to be kind of disinterested. Don't focus on yourself. Don't focus on your needs. Focus on what is best for the individual that you are trying to benefit as part of that trust. And so it's a very, very high standard. one that goes back, again, hundreds of years, predates the United States, essentially. So these are old established rules. In terms of the obligations of the fiduciaries under ERISA, ERISA Section 402, plans have to be maintained pursuant to a written instrument. So let's pause for a second there. That is an important thing. We occasionally get questions from clients where they'll come up and say, hey, we want to, set up kind of a separate little plan to reimburse individuals for their medical expenses. Joe is having a hard time over here, and we want to start reimbursing Joe for his medical expenses. You can do that in general, but you should probably have some kind of written plan document, some written SPD, some additional written terms, which kind of lay out everything in terms of what that reimbursement for Joe's medical expenses are going to be. Is it just Joe participating? Is it others who are participating? What medical expenses of Joe's can be reimbursed? In addition, although I didn't call it out here too, the Internal Revenue Code is important too, and they kind of interplay. So for example, under the Internal Revenue Code, in order for those reimbursements, in order for the health benefits which are going to be provided to Joe in this hypothetical, in order for those to be non-taxable, the Internal Revenue Code generally requires that there be a written plan document which specifies what the benefits are going to be. So again, putting things in writing, very important from a ERISA and tax perspective. ERISA Section 403, if there are plan assets, they generally have to be held in trust and cannot benefit the employer, cannot inure to the benefit of the employer. So they can't go back to the employer. I would say for 95% of our single employer clients, this is not that big of a deal. There's some Department of Labor guidance which says that in general, participant contributions don't really have to be held in trust. So you kind of get away from some of these rules. For 5% of our employer clients, they actually have a trust, and then you have to kind of jump through those hoops. You have to deal with those issues. If you do happen to have a trust, again, if you're in one of those kind of a minority of employers who has a trust, there are heightened fiduciary duty responsibilities there too. You just have to be very careful because all the amounts held in trust probably are plan assets, probably are subject to all these fiduciary duty rules like those in Section 404. Where again, we're under 404, you have to kind of wear your fiduciary hat. You need to act in the best interest of plan participants and beneficiaries. At least when you're doing fiduciary activities, when you're doing kind of settler activities like designing the overall terms of the plan, those fiduciary duty rules generally drop out. ERISA Section 406, prohibited transactions. Prohibited transactions are ones that we'll cover in a couple slides in a little bit more detail. Just wanted to give you a heads up that they're important also. In terms of the 404 fiduciary duties, let's kind of drill into those a little bit more. A1A is a duty of loyalty, so you're supposed to act in the best interest of plan participants and beneficiaries. A1B is a duty of prudence. So basically they're saying that you need to act prudently as a good, knowledgeable fiduciary would act in that situation. So it's a pretty high standard. Again, if you are sort of a newbie rookie fiduciary, you just joined a benefits committee or you just became the benefits director and suddenly you have to make all these decisions yourself. This duty of prudence standard is a tough one because even if you are acting kindly, even if you are trying to read up a little bit, you could be held to sort of an expert level from a prudence perspective. Again, the risk gets magnified if there are assets. If there are assets, you're going to have to diversify those investments. Again, most health and welfare plans don't have investments, but some do. Very common in the Taft-Hartley space, the multi-employer space. And again, some usually larger single employer plans have trusts where they have assets, and you have to diversify those assets. A1D, duty to act in accordance with the plan documents. Very, very common for situations to come up where your health plan maybe doesn't cover a particular medical procedure or the TPA is saying it's experimental or investigational, but you want to cover it. And in general, what we tell clients there is you should modify the plan document because you're supposed to act in accordance with the plan document. So you can usually accomplish it, but again, it's a good idea to kind of put it into writing. In addition, TPAs and PBMs, when you kind of steer off the written plan, they will often require that you put into writing and sign a contract saying that you are directing them to take actions outside the plan. One other point on that too, stop loss carriers. If you're self-funded, many of you will have stop loss insurance. You should get approval from the stop loss carrier before you deviate from the plan document or add new terms to the plan document. One of the worst situations is when you kind of deviate from the plan documents and then you end up in a situation where the stop loss carrier denies a high cost claim. We see this a lot with regard to eligibility issues. You'll have somebody who it's a heartbreaking situation. They're a long-term employee. They've been there 30 or 40 years. They have a medical issue. You keep them on the plan even though they're not eligible under the terms of the plan. Then those medical issues pile up. They have $1 million in claims. The stop loss carrier says, hey, not our problem. You have to deal with it. So again, think about those kinds of issues when you're contracting with the stop loss carrier. Prohibited transactions, kind of a lot going on here. What are we trying to say? The ERISA rules say that if you have a plan asset in general, then you can't misuse that plan asset. How would you misuse that plan asset? Basically, if you engage in a transaction between the plan and a party in interest. Party in interest would definitely be like a fiduciary, an employer, including service providers too. So again, if you said, we have a funded plan, we want to hire ourselves to administer the plan, that's oftentimes problematic under the ERISA fiduciary duty rules. That's oftentimes a prohibited transaction. Prohibited transactions are illegal. They can be subject to a penalty of like 100% of the amount at issue. So they're very, very significant concerns. So again, be careful with those prohibited transaction rules. They can really kind of trip you up. How should you be careful? One way that you should be careful is by focusing on ERISA Section 408. ERISA Section 408 provides various exemptions from the prohibited transaction rules. For purposes of this webinar dealing with contracts, the most important one is ERISA Section 408B2, which says that you can use plan assets to pay for necessary actions with regard to contracting. So again, if your plan needs to hire a TPA, needs to hire a PBM, needs to hire a lawyer, folks like that, you can use plan assets, but you need to make sure that that contract meets the ERISA prohibited transaction exemptions. If you don't have any contract, almost by definition, you do not have an exemption, and therefore you have violated ERISA. So again, be very careful if you don't have a contract with a particular vendor. Handshake agreements, not going to cut it in this situation. So again, be careful there. How do we kind of prove that our contract meets the ERISA rules? Well, one of the big things is that a contract is going to be reasonable only if the required fee and other information is disclosed to a responsible plan fiduciary. So again, fees are really, really important. In the retirement plan context, there are thousands, maybe tens of thousands of cases out there where plan sponsors, plan fiduciaries have been sued over improper fees, undisclosed fees in the retirement plan context. Health plan context, we have seen fewer of those, but they do exist, they do happen, and we have started to see additional cases in this context. Johnson & Johnson has been sued, Wells Fargo has been sued. There are other examples out there too. So those cases are kind of moving through the courts, and everyone's kind of monitoring them to see if there will be kind of an uptick, a groundswell in some of these fiduciary responsibility cases in the health plan context. So again, walk through, ERISA Section 408, make sure that the terms of your contract are reasonable, not just fees, but other terms, including your ability to terminate the contract, including limitations of liability, insurance issue. So again, everything is sort of at play in terms of making sure that those contracts meet ERISA Section 408. If it turns out that you think that you're not deficient, you can actually go to the DOL and kind of report the situation. That's a rare event. Most of the time, employers just try to work it out with the vendor. There are also new reporting rules, new disclosure rules for broker services and consulting services. So again, if you have a vendor who engages in brokerage services here or consulting services on the next slide, you need to make sure that they're providing additional disclosures, particularly around fees. So again, look at this broad definition of brokerage services. This will pick up a lot of your broker activities. So again, the question is, has your broker started providing additional disclosures? Do you even have a contract with your broker? Do you have some kind of disclosures that they're making? If not, probably appropriate to revisit that issue. Consulting, similar. Many of you are going to have benefit consultants. Those benefit consultants are going to, give you guidance, give you advice about benefits administration, how to set up a plan, stop loss insurance, pharmacy benefit management services, things like that. So again, look at your contracts with regard to your consultants. Are they fully disclosing their fees or not? In terms of whether TPAs are covered by this, probably not. Most TPAs, I think, really don't engage in consulting. They engage in just the administration of the plan. So that's how we typically see it. But there's nothing stopping a TPA from engaging in consulting services. So you should kind of look at that and try and verify what is your TPA doing. If they are engaging in consulting services, you need to make sure that that contract with the TPA contains these additional disclosures regarding compensation. All right, typical vendor contract terms. Other things to think about here. Again, kind of focus on what your plan does and whether those activities are internally performed using the employees of your plan as a plan sponsor, or done by outside entities. Most, maybe all employers usually have someone internally who helps manage the plan. So you will have a benefits director, you have a benefits coordinator, you'll have an associate director for benefits, whatever the terms are. Those folks typically help administer the plan. They're dealing with questions from plan employees, they're coordinating with vendors, they're making sure that the train is running on time. Very, 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 very rarely will we see a plan sponsor try to charge for those activities. They'll try to say, okay, we pay that person the equivalent of $100 an hour, and they worked on the plan for 20 hours this week, so we're going to charge the plan $2,000. It is possible, maybe, but you'd have to deal with some thorny, prohibited transaction issues. So again, that's kind of an unusual situation. If you are doing it, again, you may want to build something in from a contracting perspective. There would be no HIPAA business associate agreement needed in that situation for actions of the employees of the plan sponsor. But HIPAA is a contracting issue that you need to deal with because if the folks within your organization are going to see protected health information, PHI, then you need to amend your plan document to allow those people to be in a firewall within the company and to get access to that PHI. So that plan amendment basically is a contract where you're kind of saying, yes, we agree to follow the HIPAA rules. So again, be careful there if you're going to go down that path. Many other common functions of plan administration are outsourced. So again, usually you'll have somebody internally handling some things, but much of this is going to be outsourced to third parties. So what are the typical kind of vendors who are out there? Think about who acts as your third-party administrator, your TPA, who engages in claims processing, appeals, utilization review. Again, usually a TPA. Medical review expert. Many employers, maybe 20 years ago when HIPAA privacy first kicked in 2004, said, you know what, we don't want to see all these appeals. This is a lot of health information. Let's outsource appeals to TPAs and PBMs. And if you do that, that's fine, that works. But some employers still like the appeals to come back to them, or your TPA or PBM may want the appeal to come back to you. And in that situation, that works. That's fine. Again, it should be in the contract in terms of them, hearing the appeals or kicking them back to you. If they're kicking back to you, you may want to have a medical review expert. There are entities out there that provide guidance to fiduciaries and say, okay, we think that this particular claim is medically necessary or not medically necessary. We think this particular claim is experimental or not experimental. So again, if you are in that space, it helps to hire an expert because, again, from an ERISA perspective, you're going to be held to that expert type standard. PBMs are another, again, very common one. They handle prescription drug claims. Benefit consultants or brokers, again, just talked about those new 408 disclosure rules that, again, should be in your contract with them. Telehealth vendors, kind of a newer one in the spectrum of vendors who are out there. We didn't really have telehealth vendors 20 years ago, but very common now and a very helpful way of providing additional benefits and support. Wellness vendors, again, wellness vendors are generally going to be subject to a lot of these rules. Enrollment vendor, probably not really subject to all the ERISA rules, but again, very helpful to have contracts in place with them. Cafeteria plan administrators, kind of the same. Cafeteria plans generally won't be covered by ERISA, but nevertheless, you should still have some kind of contract in place with them. Other vendors, EAP, Employee Assistance Program vendors, health reimbursement arrangement, HRA vendors, health flexible spending account, health FSA vendors, dental, who's your dental administrator, vision, who's your vision administrator, short-term disability. Let's talk about this one for 1 second. We'll pause on it. Short-term disability plans can be considered payroll practices under ERISA. And if it's a payroll practice under ERISA, then ERISA is dodged. You don't have to treat it as being subject to ERISA. There are some Department of Labor standards for what is considered a payroll practice versus a non-payroll practice. Take a look at it if you haven't looked at it. Clarify whether your STD plan is subject to these rules. That is helpful. LTD, long-term disability, again, very common. Life insurance also. Auditors, again, good idea to have a contract in place with them. A COBRA vendor, very common to outsource COBRA to someone other than your TPA. Accountants, on-site, near-site clinic providers, direct contracting. Again, let's pause for a second here. Many times your network is going to be provided by a third party like, the Alliance or a TPA or someone like that. That's great. Sometimes we have seen clients say, let's just cut a special deal with this local healthcare provider. They're not in our network, but we have a lot of demand to use them. And so you can directly contract with the healthcare provider. Again, think through those same kinds of issues because you're really kind of negotiating the rates. You should do so prudently, again, in the best interest of plan participants and beneficiaries. Actuaries, stop-loss insurers. Stop-loss insurers are very important in terms of, making sure that you like the terms of the policy, making sure that that exceptions exist. So again, look at their contracts because when you start talking about disputes with the stop-loss insurer, the dollar amounts are usually very big. Normally you're talking hundreds of thousands of dollars, maybe over $1 million. This is usually not, we don't see a lot of $5,000 disputes with stop-loss insurers. So be careful there. Specialty network vendors, for example, for organ transplants, you may want to send people to a center for excellence to get that particular organ transplant. Last but not least, attorneys. Attorneys can certainly be vendors to health plans. And again, you should make sure that your contracts are good from an ERISA perspective there too. All right, so that's kind of the plans and the different ones which are out there. And I should probably pause for a second here. Jennifer, any questions so far? I just want to double check. Oh, I didn't hear you there, but that could be me.
Yeah, we actually got a question about slide 11. It mentions that most plans require participant contributions. And the person asked if you could elaborate on that because
Sure.
they've considered a $0 premium, $0 copay plan for employees. Essentially, they wouldn't have to pay that. So as long as they went to certain providers, it'd be free. Is that allowed?
Yeah, that's a great question. So, yes. And I don't want to back up, but because then I'll probably get everything all mixed up. But yes, in general, most companies do require participants to contribute towards the cost of the plan, whether that's on a premium level, a co-payment, co-insurance level, or both. That they're very commonly most people are paying both, to be honest. So, but with that being said, you don't have to structure it that way. You could have a zero cost free plan, that has no premium associated with it, that has no deductible, that has no out of pocket max, that has no co-insurance. So you can do kind of whatever you want there from a legal perspective. Obviously, it's probably pretty pricey. You're going to have a lot of people join the plan if it's free. So maybe kind of a magnet. The legal implication of having participant contributions from a contracting perspective here is that the Department of Labor has said that participant contributions are ERISA covered plan assets. The fiduciary duty rules that we've been talking about apply to ERISA covered plan assets. And so if you said, you know what, we don't want to deal with ERISA plan assets, everything's free, then there's no participant contributions, it's only employer money. You might be able to sign a bad contract without breaching ERISA because it's all employer money, no participant money, no plan assets. So again, that's so rare that it's very unusual, but it is theoretically possible. Yeah.
Great. We have some more questions that we received beforehand, but I would say you can keep going and we'll get to those at the end.
Sounds good. Thanks.
Thank
All right.
you.
Other, basic questions, how to hire a vendor. That sounds pretty easy, right? You just hop on the internet, you type some things into a web browser, and you pull up some names, and then you try to hire one of them. That's not the best way of doing it. So what you want to do is you want to establish a prudent process. What do we mean by prudent process? Try to create a request for proposal, an RFP. Try to identify the things that you want to have in the RFP. What are the terms? What do you want that vendor to do? What are the conditions? Send it out to 3 to 6 vendors and then wait for them, give them a month to respond, and then put together a spreadsheet or other summary, and then have a group of folks review the summary. So usually, again, I don't like it when it's just one person within a company kind of doing everything. I think it's good to get everybody's input. That's helpful. So, a formal benefits committee is kind of the gold star standard. That's kind of a really helpful process where it's very clear who's making decisions and how they're handling it. Again, in that RFP I mentioned, think through what are the must-have terms that you want in the RFP. For example, limitations on liability. Almost every vendor is going to say our liability is going to be capped at, $50,000 per error, or $1 million per claim, or 4 times the fees that you pay us in the last 12 months, something like that. So, again, if you don't want limitations on liability, bake it into the RFP ahead of time and try to make it clear this is what we expect our vendors to agree to ahead of time. If you don't agree to it, then maybe you don't submit the RFP, or you submit the RFP and you propose specifically where you're deviating from these terms. Access to plan data. This is kind of a big one. There's been ongoing disputes about whether, for example, employers can get access to TPA held data or PBM held data. So again, we see that baked into RFPs often. Indemnification, if there's a lawsuit, are you paying for the lawsuit? What about the ability to easily terminate the contract? We often agree for sort of a 1-year lock-in, if you will, because it takes the vendor some time to kind of recoup their costs. But after that, we want in general, the ability to get out pretty quickly. 60 days, 90 days advance notice is pretty, common, I would say. We have had some clients get kind of locked into like a 5-year contract, and that's a little bit risky from an ERISA fiduciary duty perspective, where there's no termination for convenience, because what if after the first 6 months, the people that you work with right now who you really like, they leave, and the replacements aren't very good and the service goes down? You're still locked in for 4.5 years in that example. So that can be a little bit stressful. Again, putting these must-have terms in the RFP, I think, gives you a much stronger negotiating position. Before the vendor knows that they won the RFP, you have a lot more leverage. Once the vendor knows that it won the RFP, employers lose a lot of that leverage. So again, kind of think through it strategically up front, and work through it that way. You may also want to consider asking for their template contracts. Most of these vendors will have a template contract. We oftentimes don't look at them until like the first round. So if you send it out to 6 vendors and then you eliminate 3 so there's 3 finalists. At that point, we tend to look at the contracts and say, okay, here's the 3 finalist contracts. Here's our comments. Here's some things that we like. Here's some things we don't. Again, looking at that ahead of time is helpful. Other factors to think about, how important is cost? Cost is important, but you do not, under ERISA, have to choose the least expensive vendor. So again, focus on cost, document what the costs are. That's very helpful. That'll protect you from a fiduciary duty challenge at some point in the future. But there's lots of other things that are important too. Experience, number of clients, reputation, prior results, network coverage, disruption to provider relationships, recommendations. If you've heard good things from your colleagues at other companies, from your broker, things like that, that's important too. Technology, service levels, contract terms, business stability. Have they had a lot of turnover? Cybersecurity. So a lot of other factors. Again, if you went into it with the attitude of we're just going to pick the cheapest one, that's probably not a good approach either. Because again, you're held to a high fiduciary standard. You should kind of take into account all these different factors. When you ultimately do choose one vendor, put into writing why you did that. We've had clients come up with scoring systems. So they'll say, it's on the scale of 1 to 10, this vendor got an 8 on cybersecurity, this one got a 7, this one got a 5, this one got a 10, and then add up the scores. And maybe that, top vendor is the one that wins. Also a good idea to do periodic RFPs, no set time period, maybe every 3 to 6 years. 10 years, I think, is kind of too long. Anything beyond 10 years, I think is very long. So again, if you haven't done an RFP in a while, if you've had the same TPA or PBM for 15 or 20 years and you haven't looked at anything, it's definitely a good idea to kick the tires, see what else is out there, go through a formal RFP process. Other terms to typically include in contracts, the effective date of the contract, the length of the agreement. Again, usually you want it to be not overly long. If it's a 5-year contract, but you can get out after 90 days, that's fine. That's not too long because it's not really a 5-year contract at that point. So again, be careful there. Does ERISA require a termination for convenience provision where you can terminate upon, say, 90 days notice? There is Department of Labor guidance that strongly suggests yes, unless the plan sponsor can prove that no vendor offered that kind of term. So if every vendor requires 3 years, you're locked in, you can't do anything about it, you'd want to document that, hey, this is the best that we could do. But again, be careful there because there is DOL guidance there. The scope of the services, try to be as specific as possible. For example, I've seen some TPA contracts where they say they will perform claims processing. That's it. Well, what does claims processing mean exactly? Are you going to handle appeals? What third-party vendors do you use? What about notices? Are you going to send out denial notices? What about external review? Who's going to handle that? So again, the vendors will have an incentive to kind of keep things really high level. hey, we'll do claims processing. You're going to want to push back a little bit and say, no, walk me through the details here. What exactly are you going to do? Software AI, this is new. I hadn't really ever talked about artificial intelligence until probably the past 6 months or so, but it's an interesting area. Most of your vendors like TPAs and PBMs are going to use claims processing software. That's in general fine, right? So if a claim is clearly not covered, it's just not covered by your plan, we don't necessarily need a human being to come to that determination, because the software can be designed to automatically say, hey, claim is not covered. Here's your explanation of benefits. If you want to appeal, you can appeal. Where it gets a little bit more interesting is on artificial intelligence. Why is that? Because one of the ERISA rules, according to the Department of Labor, is that claims be consistently decided. So if Ed has a claim in 2024, Sally has a similar claim in 2025, will the TPA software decide in 2026 that Alice's claim is going to be treated the same way? You want consistency from an ERISA perspective. AI right now, as I understand it, tends to hallucinate in some situations. And so meaning that it doesn't always treat things the same in a consistent manner. We are seeing some new regulations begin to creep in. For example, there's a new California law on AI in the health insurance context. So it wouldn't really impact most of the listeners here today, because it's more on the fully insured side. But it requires, for example, that claims be consistently decided. Medical necessity reviews, one of the things we talk to clients about is that appeals or medical necessity reviews should be done by a human being, that we don't necessarily want that to be fully automated or done by AI. If somebody's bothering to go through an appeal, the dollar amounts could be significant, things like that. So maybe bake that into TPA contracts, PBM contracts. That is not a standard term, by the way. I've never seen a TPA or PBM specifically address this. So this is a good one for you to put in there, even though they may not have put it in there. Other terms, compliance with applicable law, not just the law that applies to them, but also the law that applies to you and to your plan. So try to make that clear. Other general terms in contracts, what if the vendor says it's not an ERISA fiduciary? Well, that's a pretty typical term in a health and welfare plan contract. And if they're not a fiduciary, then that's fine. It's accurate to say that they're not a fiduciary. But if the vendor hears the final internal appeal of a denied claim, that generally makes the vendor an ERISA-covered fiduciary. So you should modify the contract to have it reflect the reality. So again, it's not ideal to have the contract say you're not a fiduciary when they really are. Again, you want them to kind of match up there. You should also specify the duties of the employer. What are they asking you to do? Provide accurate enrollment information in a timely basis, things like that, fund claims. Again, what are your obligations there? How claims are going to be paid? Will you have to create a separate checking account that the TPA can pull from? Maybe a formal trust, they might require that. How do they get access to it? Things like that. Other terms, who's going to draft all these different documents we talked about? SPDs, SBCs, who distributes them and when do they distribute them? HIPAA. Definitely talk about HIPAA. You may want to consider additional privacy and security terms beyond HIPAA. A couple months ago, we did get new proposed HIPAA security rules, which would significantly update them. Kind of a whole revamping, kind of a radical restructuring of the HIPAA security rule, which is not a bad idea. HIPAA security rule became effective in 2005, so it's over 20 years old. And as you can imagine, electronic security has changed a lot in the past 20 years. So I think most people say, yeah, it probably should be updated. You don't have to build them in now from a legal perspective, but some of them are kind of helpful, and you may want to build in some terms right now. So again, don't technically have to, may want to sit back a little bit, but some of the concepts probably could be updated there too. Breach notification rules, deal with those. What about indemnification, timing of reporting? How quickly did they need to tell you about a HIPAA breach? And then what happens with the costs associated with that? If you have to set up a telephone hotline to address participant calls, who's paying for that hotline? Who's staffing it? Things like that. Customer service personnel, the time that the phone lines are open and where they're going to be staffed, maybe you want it to be, United States-based staffing, perhaps. After the contract terminates, because it probably will terminate at some point, maybe guaranteed that the documents are sent to a new vendor, hopefully at no charge, but sometimes vendors do require that. Bonding and insurance terms. If your vendor is dealing with plan assets, they should probably be bonded from an ERISA perspective. Insurance terms, no set dollar amount for insurance terms, but pretty normal to ask for insurance in the millions of dollars. So, errors and omissions, cybersecurity, things like that, pretty normal to ask for significant terms there. Standard of care, you need to make sure that they're providing good services, probably the services that a national experienced vendor would provide. If errors occur, the vendor will fix them or try to fix them. And then maybe if they can't fix them, then maybe they need to report them back to you. We've been trying to build in like quarterly reporting for plan errors that they couldn't fix. No gag clauses. Basically, there's a new gag clause rule from the CAA, Consolidated Appropriations Act, where plan sponsors should be able to get access to their claims data. There's a very important new FAQ from January, which deals with downstream entities. Basically, if a TPA has a contract with a health vendor or other third-party vendor, now the new FAQ says that you as the plan sponsor are responsible for making sure that that downstream agreement doesn't have a gag clause in it. That's a really bad result from an employer perspective, because you only see the contract between you and the TPA. If that TPA has 400 contracts with other health vendors out there, you don't see those other 400 contracts. So you need to put into place some language in the one contract that you do see that there are no impermissible downstream entity gag clause provisions. Also, because that was a, quote, clarification from the regulators in January, it's immediately effective. So they gave us basically no compliance lead time. The day that they publish it, it was effective, and they expected everyone's contracts to be updated. So that's a big one. Just wanted to point out that issue there. Other things, subcontractors. Are you going to allow subcontractors delegations of duty? Maybe consider putting in some limits, perhaps. Audit rights, can you get access to your plan data? Again, if you have good gag clause language, that becomes less important. Disclosures of additional fees or revenue, you may want to put this in. For example, if your vendor is receiving hidden payments from third parties that they don't tell you about, and then they recommend those third parties to you, they're not necessarily unbiased. Now, that may be the best third party in the world, but you may want to take into account, hey, you're perhaps making this recommendation on the basis of the additional, compensation that you're getting. Other terms to include in contracts: arbitration provisions, mandatory or voluntary, are not allowed at all. Litigation provisions, very normal for a TPA or PBM to ask the employer to pay litigation costs if they're just doing their job and following your plan document. In general, I tell employers, yeah, that's pretty reasonable. You should agree to it. But you should consider carve-outs and exceptions. So, for example, if the lawsuit is caused by the errors or the bad processes of the TPA or PBM, then you shouldn't have to pay for it. That should be their cost in that situation. So, again, do spend some time on the litigation provisions, including the venue. Where will the lawsuit be brought? You probably want it being brought where your headquarters are, for example, not in some other states. Some terms you should consider as post-termination. So there's a new lawsuit from the DOL, new in 2023, where the DOL brought a lawsuit in Wisconsin against a third-party administrator, wanted the third-party administrator to reprocess claims all the way back to 2015, so going back 8 years. Well, in that 8-year time period, you will have had situations where the employer no longer uses that TPA. They fired that TPA at some point during those 8 years. But the DOL might say, we don't care. We still want you to give us access to this MAPIA information. We want you to reprocess mental health claims. At that point, you'd have to go back kind of on bended knee to that TPA and say, hey, will you agree to help us out here? that's uncomfortable, right? They don't have to do anything. They can tell you to get lost. So again, consider putting in post-termination provisions into that contract. Other terms to include in contracts, again, kind of go through those different benefit laws and think through things. For example, the CAA did impose significant new requirements. We talked about the MAPIA rules and those NQTL rules. There's new prescription drug reporting that kicked in a couple of years ago. Definitely think through who does that prescription drug reporting for you. New air ambulance reporting that we haven't done yet. That keeps getting kicked down the road. The can keeps getting kicked down the road in terms of the effective date here, but it will be coming at some point, we think. There's increased transparency rules, increased disclosures about hospital costs, advanced explanation of benefits. So again, think through who's doing those activities on your behalf. No Surprises Act protections. There are some new rules there. Again, especially with regard to your TPAs and PBMs, bake those in. Other steps to minimize risk, consider a self-audit. So, kind of think through, okay, what are the gaps that we're missing here? What, if we look at all these different laws and we read these different cases which are out there, what are we missing? What else should we be thinking through? Review what others have done well and not so well. There are a lot of different benefit groups out there. They have regular meetings. Talk to your colleagues at other companies. Go to webinars, listen in on things. Read the news that comes out every single day. So kind of think through all those things. Establish clear actions of fiduciaries. Again, benefits committee is great, but again, think through who also does other kind of non-fiduciary activities too. And then if you do have a benefits committee, think through, did your board or other top level formally delegate responsibility down? Could you prove that you have that formal delegation? If you can't prove it, if you think it happened 50 years ago, but nobody can find a formal delegation, maybe have them reapprove it so that you can actually prove that you have authority to act. Think about hiring and consulting professionals, actuaries, attorneys, consultants. And again, monitoring vendors and changes in the law. All right. So, Jennifer, that was a lot, but I think we have a little bit of time for additional questions here.
Yeah, thank you so much for being with us today. I want to thank you, those who took the time to submit questions in advance of this program. I'm going to ask just a couple of them. How should I respond if my vendor refuses to provide a certain disclosure?
Yeah, so you could certainly, take the steps of trying to put pressure on them yourself, right? If it's a legally required disclosure, you could hire, an attorney to come out and kind of beat them up a little bit and say, hey, we think you need to make this disclosure. You could also report them to the DOL. That's not comfortable, especially if they're a current vendor. So, you should start with the, hey, we really need this, and then kind of escalate up, I guess, from there.
Okay. Can governmental plans ever be subject to ERISA?
The short answer is no. They can't ever be subject to ERISA, but there can be confusing situations. Like, for example, some governmental statutes will create kind of quasi-governmental entities. So they'll create a bus service, and the bus service charges fares to passengers and really operates as a for-profit entity, but it was created by a statute. Is that a governmental entity or not? The analysis is very difficult in that situation because it kind of operates outside the governmental realm, but the government could get rid of it. So those are kind of the most difficult to determine. But a pure governmental entity, city, county, state, no, ERISA will not apply.
Okay, thanks. How will the current administration's stance on transparency impact my contract negotiations?
Yeah. So the Trump administration just came out with a new executive order talking about, price transparency, kind of putting their thumb on the scales in favor of transparency. So we think we'll see additional guidance there. We think that there will be increased pressure on TPAs, PBMs to keep disclosing information, but we don't have that guidance yet. So we're kind of gazing into the crystal ball. nothing you can really put in from a contract perspective yet, other than maybe compliance with applicable law. So if the law changes, next week because they come out with that guidance, if you've already baked it into the contract, then maybe you don't have to update the contract.
Great. Thank you so much. I know we're out of time, so that wraps up today's event. I just want to thank you again, John, for joining us today. We really appreciate your time and insights on this important topic. If you need additional resources, please reach out to the account executives here at the Alliance. We have experience in benefit plan design and are happy to assist you. And if you're not a member and are interested in learning more, please reach out to our business development team. If you'd like a copy of today's slides and aren't able to download them, please send an email to events@the-alliance.org and we'll be happy to email you. If you're watching this webinar live, you can claim CE credit by clicking the View Certificate buttons on your screen or in the Engagement Tools drop-down box at the top right corner. And finally, we'd love to see you in person at our annual Spring Symposium in April. We'll be hosting a half-day data analytics workshop the day before, and hotel rooms are available at our group rate. We'd love to see you. Get all the details on our events page. And thank you for joining us today. Remember, when you think of the Alliance, think self-funding smart. Take care.